All right. Now, I wanted to give Victoria the opportunity to sort of put it into context of what's available in Australia, because ultimately, if, and we'll get into when is it that a potential client could bring a claim in the United States, but if the client does not want to do that, or for whatever reason the United States courts are not available to that client, well, you can also give the client the opportunity to look at what would be available to him or her in Australian courts.
Thanks, Carlos. I think, first of all, something to note is that if Australians are bringing their claim, a cruise claim in Australia, it's not necessarily going to be Australian law that applies to remedies. And the traditional approach in Australia is for tort claims. It's the law of the place where the tort occurred, which is going to apply to damages. So with maritime cases, if a ship's moored or docked in the territorial waters of a country, then it will be that country's law that applies to damages, even if a claim is brought by an Australian here. If the tort happens on the high seas, then the law that applies to remedies will be the law of the flag state where the ship is registered. The breach of contract claims, it's the proper law of the contract that applies to remedies. And it's interesting what you said, Carlos, about contractual clauses for US cruises, because most cruise lines that sell to Australian passengers have in their terms and conditions, most of the passenger contracts are subject to New South Wales law. So in that case, it would be New South Wales law, which is my state, that governs remedies for breach of contract claim. But it will depend on booking for each passenger as to which law applies. And then lastly, Australians have the protections of the Australian Consumer Law, which is found in Schedule 2 of the Competition and Consumer Act. And without getting bogged down on the very complex interplay between that federal law and different jurisdictions' civil liability legislation, remedies are basically subject to Australian law in very general terms. So I guess first up, it's not necessarily going to be Australian law that determines the remedy that Australians can get, even if they bring a claim in Australia. But when it is Australian law that applies, the heads of damage are very similar to what you just described, Carlos. But unfortunately, we have various caps and thresholds over here. So for wrongful death claims, it's essentially just dependency claims that we can bring. There's no sort of bereavement award. And in cases where people are injured but don't die, there's caps and thresholds for non-pecuniary damages, so general damages or non-economic loss, it's called in some jurisdictions. There's caps on children's care you can get, there's caps on lost wages if you're a very high income earner. So in general terms, remedies are the same in terms of heads of loss, but unfortunately in general terms, but we do have a lot of caps and thresholds, which you don't seem to have in the US.
And that's a very good point. We don't have caps in general maritime cases. So any case that involves a cruise ship in the United States touching a US port, then the federal maritime law applies and there are zero caps. And what that means is we were discussing this, an interesting distinction with Victoria. For example, these cruise ships carry very sophisticated medical facilities. They're basically floating mini hospitals. They have x-rays machines, they can give people serum, they can